Nkansah say ya meda a year team of producers meda omase meda Kofi Ntwase ene awie na mada a year iced tea so meda das papa ene awie ono eno waha obua echinchim a year cameras no ede amame MCR Nana Kwame ewo MCR a obo adwuma kama nso ewo ho na yatenase ene eye 21st July 2026 barely 24 hours after the bad news of the incarceration of Chairman Bernard Entry Buesiakon, otherwise known as Chairman Wuntumi. Enra, don't wanna say a Black Monday. And indeed, it was a Black Monday. Enra, quite unfortunately, meant to me Aunt Nancy. But meda a year Nana Fokuo Jumo meda na sipawapa for sitting in for me Enra. Meda Fokuo ase. Ene yes ye sukra ye jai him. Adum bintino yatinase. Na lots and lots of water has gone under the bridge 24 hours. Social media call for extra adwin na asam eba se ya omo a edi areho me expect say asase a ye wosu yi obia ena epe obi asem omo a edi areho omo a omo ani age enso ani age because they are friends and they are definitely enemies. Eti ibi dodo na esre dodo na nso ensu the late Daddy Lumba or Simpempem Dome Mpempem so na time sa ena Chairman Bernard Entwibuasiakon etie Mpempem edo Chairman Bernard Entwibuasiakon most definitely Mpempem so na etano sa ene wiase etie Bible pra more or less waka enyo bia na bepe wase. But ene ewie adum yen yatenase heartbroken, but there is hope for the future. Ene si adum yen yatenase although we are heartbroken, but yachichi yere we keep on keeping on. And then every the news in town, major news in town, headline stories still remains that of Chairman Bernard Entwibuasiakon, the bankroller of Wuntumi Multimedia. But then or no ena or yet the Ashanti regional chairman aspiring to be the national chairman. And then the NDC has succeeded in jailing the Ashanti regional chairman of the NPP. Yes, it was expected. Although a buyer, a GNC more or less, but more or less sooner and young because we share said the idea no aircraft. Now there was every calculated effort. Some every penny chairman want to be down. The Ashanti regional chairman, or no, and then another thing. Into ye kano eshema. Ye. Question is, Omo eche chairman want to me no. Omo na ye. Na take note. Chairman would to me and a yamede, say lawyer waha. Chairman would to me omo eche no, and that's omo ejele no. Menye mistake, memo bin the other. Onye galam say so da. Debioka court judgment e ba ye no, ye hu baby omo oye galam say. But then so the ya mobi na obi to assassin owna and the lawyer wa ye bedin komo enti chairman want to me for the records enye illegal mining onye illegal miner on to galamse onye bida records no from head to toe chira be baby almost oye galamse and the bedin komo what it is several to do that and then so ye bedin komo. But then, Omunswa, Omudiaka oral ho, because Justice Srebsai, Omu kreti oral platform bi Omu kokota oral case say chairman would to be non yet government appointee. Abayin bi ama chairman would to be adwuma so nye. Won bi sa se NDC for Omu ba Omu oral a Omu ye hu dede no. That chairman want to be case eka oral no ho ana Debbie. Enti memo bin dada say oral is dead. Oral wait then come oral no ho. Chairman want to be near government appointee on cover abansika wi abansika. And then somebody who say national service dey be trending. Say be yan bram abahumpa. National service die bi who say sika die bi aba ho a Suleiman Ibrahim anum esade trend but then eno nyem be focus for now ebrebe man ye be hwe enti chairman would be near bicycle on fan in sambas bicycle mu enti ora do mo obi be fan be ka ora we nka ora but the gida no bi twa de ti ade to me ewura nsem do mo no ene judgment no ababonti quite unfortunately ABB accept maka bin to me enra a year 59 paged document no engina judgment na bia benjebre enra mu but the lawyer wahana yebisa the relevant questions a kwai omo fan so ejele chairman want to be me say no lawyer waha but lawyer Evans was able to esa ewaha enche One Honorable Frank Edusipoku, former DCE for Sunafo South, or also Ebert Nasi Jumedie, so na Yashe in Semino. Na judgment, my country say judgment, na Abba Abonte will try and make meaning out of a judgment. Abba Abonteno say Empo Omubo Munkrowie, Matibro Fubi, circumstantial evidence. Bro, be circumstantial evidence. Say no, and no, you're dying, and a circumstantial evidence. A judge, you know, when you evidence, actually, a lawyer will have evidence. Say lawyer Evans, I will have them, and every not just Obubo Munkro in area, you know, Henry Okumuno, then the judge, you know, if we die no TNT, and no, or this our judgment, no, Abba. But it be so more cancer. Now, I contaminate a corporate. Nkansah firm that can sue and be sued. Na ebinum question omo bisa yegusa contamine but I think that question arises say why separate there are a whole lot of questions regarding that. But eventually the question is say director na omo ejeli no chairman won't be as the director omo akwa ba be jeli no. Is it right? Judgment aba and the lawyer wa ha won't ye be beside who questions na ye mu because don't wanna na charge lawyer wa ha ABI you missed an opportunity and the lawyer wa ha the ebira sa in seven engineer na woswate in seven asi ABI because 20 years for a director of a company that can sue and be sued. Menumentiasi ABI lawyer will try to make meaning the my area say enra ne lawyer no work court say only court eno a case kesiye dodo na e bi make reference to ye chachuchikata case send this for kro ye omu ye dede chachuchikata na the lawyer in court no and that ye den and a judge kokuvite and so acquire the same thing after the other one eba and it says Supreme Court said the lawyer for abem say Supreme Court or the Assembly Echo Supreme Court section 99 blah 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 Echo Supreme Court na empo trial judge no ampene one fanko with the assumption and I say empo no lawyer for bemudia na just say e so nya time no so steady case sans sem de nyina no e bia be ko back na ye rasa nkomo no emwena nkomo e wo ho pa was a minority aye press conference na briefly ye be kwa ko minority press conference no na and some be aba Ken Ashigbe and that Ken Ashigbe air trend na and some ama Ken Ashigbe air trend no when him say Ken Ashigbe ono kra the group na de hwan oh no mo ye group hwan against Galamsey na Ken Ashigbe ebribi omo koye petition ebra na nanado eti akonya no so against a ye chairman won't me omo the petition koy enti omo de no a omo hwa na say ye be jeli a ye chairman won't me and omo se nanado anjeli no na enwa miya mitie bi Ken Ashigbe na Nkansah bi try subscribe ebra ruling no eba ye na ni age say ye jeli chairman won't be 20 years odokra de o say Kyeremanteng 25 years. Then settled our somewhere and ye who say a ye obituary poster be air fly around. A ya some banya Ken Ashigbe a man for the it is alleged say a ye ne yire nuya penny ne yire nuya penny and the justice Kwaku te. What does it make? Me nim the other information ebe here. Ken Ashigbe as a jelly chairman wound to me 20 years na niaje edda na hokeka all over the place. Na Kyeremanteng 25 years. And na Ken Ashigbe sa ne yire numelo Kwaku te ni nia penny and the justice Kwaku te ojeli chairman won't me. It's alleged. But wait there, Nana Kwame Kabedi come out the obituary. Poster no out to TV no so at the amame. I just believe sir I sent it so to me. Aha. Monsha a year call to eternal gloria. It is alleged said Justice Kwaku te ne papa Efrimu Mr. Is it Wallingford Emmanuel Oku I beg your pardon Kwaku te na yina eboso na wo hwe din na wo ho na in-laws wo Dr. Kenneth Ashigbe bi ewo ho it is alleged said Dr. Kenneth Ashigbe ni din eno no na mo hwe ba bi a ya circle no wo hwe eye children and the children who Mrs. Priscilla Numelo Ashigbe eno eye Ken Ashigbe the yire eno no na wo hwe eye Mrs. Priscilla Numelo Ashigbe edina wo ho na on top of it ubemu her lordship Justice Audrey Kwaku te me pa cho bu wedi no hwe eye Mrs Priscilla Numelo Ashigbe the circle the green and the children na hwe esoro ho her lordship Justice Audrey Kokuvite onu eno jeli chairman wuntumi no enti under in-laws there wo ho no wo eye Dr. Kenneth Ashigbe ensu edi ewo ho Dr. Kenneth Ashigbe esi ya jeli chairman wuntumi 20 years no ne na opa no omo the petition koi sana na do enjeli no so ye illegal mining Andre buy or sit and yaji say jail in 20 years, no ya 25 krankaye. And nay ena it is being alleged. Say dunya anane yire Priscilla Numelo Ashigbe or no say dunya penny ena enra o jelly chairman wuntubin. Nyauti information we be biano. It's over to you. Information we nyauti be biano. Iti Dr. Kainashigbe ombe yina no allegedly said the yini ni Mrs. Priscilla Numelo Ashigbe a nindia pedi and the Justice Audrey Kokuvite information what the bear day ye de see her nana kwa me dance papa na nana kwa me we dem so we are Mekasa AI 10% lawyer bemu pa enti yenyi minority no and then minority MPP omo share black call brashegbe defie na omo the black na call brashegbe defie obia eni abro bia ro aho for chairman wuntumi enti ne minority domkuma no ehye tuntum call brashegbe defie na omo area no eye ma part eye press conference omo den sem kakra etuja Yankoti yebaya na lawyer ene empo honorable former DC for Sudafo South and so that's it. Nana Kwame me pacho with
others test a nation. Ghana will be judged in years to come, not by the sentence handed down in Accra yesterday, but by how faithfully we defended our constitution in the aftermath. We speak today on behalf of the minority caucus in response to the judgment convicting the Ashanti Regional Chairman of the New Patriotic Party, Mr. Bernard Kwaku, popularly known as Chairman Wintumi, and Nkansah Mining Limited. We speak not as advocates for one man, but as custodians of a constitutional order that must apply equally to every Ghanaian, regardless of political party. The New Patriotic Party has already issued its own statement on this matter. Its nation's full attention. First, the denial of a council of choice. We understand that judgment was delivered despite the absence of Chairman Wintumi's lead counsel, whose office had notified the court of a prior professional engagement abroad. Article 19 of our Constitution guarantees every accused person a lawyer of their own choice, and that guarantee may only be displaced in the most exceptional circumstances. This country once built a decade of political outreach around
sound no emma meaning problem. I think there's a technical hitch or something here. Quite unfortunately in Lanka ma yetie a year ma part and press conference omo eye ewo brashebidwafie, but quite unfortunately sound no MP and as a sound no emma. We'll proceed as said when ye bet me a correct wronger ama sound no emma no na yakwakutie ma part and a press conference omo no brashebidwafie ntia ha eye won to me TV so aha ye won to me TV so me ka wo se dwumadi no so no me etwagu ewo YouTube eye won to me TV live ewo YouTube into ubetumi join me ewo ho si say Facebook you know dabade yeah Facebook mo you mo fa eba bi na ba ochina na into Facebook de no mo ma mensa Nkansah want to be TV live on YouTube ubetumi join me ewo ho since quite unfortunately you're working on that voice as and when a voice no you betumi corrected on what sound on na ya call anymore lawyer mema kwaba
okay
na lawyer want to say
oh
yeah lawyer
okay padi nko ha
lawyer Evans Osei-Bonsu
anomentu awje
a free and we say lawyer all over the place man for my lawyer engina home o free courtroom no or grant interviews out baby no yani o
no man keke me da se
yani
asamo easy
now a very good afternoon to a young lawyer Charles Joanna Yeta from a National Cathedral lawyer. A very good afternoon to you, lawyer Charles Joanna. Baby, I will be so no. Very good afternoon to you, lawyer Ichichi our area. But lawyer Evans, and meant to be antinasi, but him sana ujumedi so na enwa Black Monday and semesi and sempin so na eguswa ekoso nkomo ekoso but yatnasi still on the case of Chairman Bernard Entry Buesiako enwa fukoni edi nkomo pi.
Yeah.
But a running story. NYBT BNT.
Yeah.
Etienne. You must say Jabrena ye real.
Okay.
Yo. Netofa. As a lawyer. Renowned lawyer.
Yes.
Evans Osei-Bonsu.
Keke obo be medi.
Case no. Yes, he is so you jai him. And na case.
In fact, and keke na me wo Central Police Station. Na me free courtroom high court na me enter Central Police Station na the Black Maria ni bi abesesa nipa bebre Ashanti region no mo operation wa tramor ne ene manema narcotics nti no match nipa bebre nti na me represent bebre wa Central Police Station. Ti me free court na interview na sha say na judgment kura me nyan huni. Me say free Central Police Station na no so eto aso na je say ultimu say enya de kacha aye busy sa Tiana Jopa na me started say me kind judgment ni be still me nwie dey on say about 59 pages. Nti I was say eto yebona ye kind judgment but baby am kind dem ehu enema kakra. Metimi ama ya pense mu kakra. Is that can be because say the whole trial ni nyina no circumstantial evidence.
Yes.
Because circumstantial evidence a pieces of information that will lead to irresistible conclusion. And it means that a prosecution only any direct evidence via etia accused person. Prosecution need direct evidence via one fenani and hunu bibia. But what the DSC nketenkete no keka boom and sign what me enya assembly sibre. And then your friend is circumstantial evidence. Now remember a typical example. And there are pieces of information that will lead to irresistible conclusion. And then your friend is circumstantial evidence. And the friend say, oh, ahoma nketenkete no asesa ntuke kan homa ni si ani ana abenya rope. Ahoma tenten kese ba ko ebomu. Aha natural say ahoma na nkasa woni bi da ho but o sesesa nketenkete na egugu ba bi no. Ana wakeka bomu ansa na watimi abenya ahoma. And then your friend pieces of information that will lead to irresistible conclusion. It means that there is no direct evidence. And now the ordinary hunu be. Not just evidence, past evidence. The hunu be bawa. So be hana. What you can see any. Now, remember a typical example. To once a judge ni go to Republic versus Duya. And no go to Republic versus Ananefiajo. Ni na cases are court on pieces of information. No, the Republic versus Duya. No, not Duya no. ɛwɔ ne girlfriend no yɛ medical doctor ɛwɔ Kwalebu ɛna dua bɔ ne tirim pɔ sɛ ɔbɛba abɛku no ɛwɔ Kwalebu hɔnom into free London na ɔbae ɔno ne the last person I think 1983 1985 thereabout Rollins mu bɔ no tu a yɛnkum nipa biem into dua bae no ɛna ɔyɛ na adwo sɛ ɔbɛku ne girlfriend no nti ɔne ne mienu kɔhyɛ dɛm na ɔwɔ ne second ku no and the samre no na prosecution ne charge dua no na oni adansie bia ɛkyerɛ sɛ dua na ekun no nti dua bie na no kan sɛ da bi ɔne ɔbaa no mienu nyinaa na agree sɛ abusuafo ha ɔmododo ntomu enku ɔmo ho mfiri wiase ana ɔbaa no yɛ sɛ ɔno de sekan ne bedi kan wɔ no ano ho to ɔde wɔ no ho no afi ɔno dua no hwɛ yɛ duru dua no so adua ɛbɛwɔ no no hu sɛ sekan na aga no de wɔ no ho no ɔbrɛ engineer de ɔno obetimi de sekan na wɔ no ho no ogyae ɔno ne defense ɔde kɔɛ na prosecution hu sɛ ɛnyɛ nokore ni prosecution ne de dansini ɛkyerɛ sɛ ɔbetimi abɛhwɛ sekan na ɛde awɔ no na hwɛ sɛ de esi wɔ no no enti ɔmokɔfa expert witness enti expert witness na yɛkɔfa no na ɔyɛ medical doctor enti medical doctor ne bae no ɛna medical doctor no ebehu ni sɛ sekan na girl ne de wɔ no ho no ekomu pa incise wound enti sɛ yɛade asekan no sɛ obi na de wɔ wa ɛbɛkɔmu pa obenya incise wound na emo wa na ɔde wɔ ho a ontimi mpia sekan no so yi ɛhɔ na court no de hu sɛ dua de ɔka no ɛnya no kora na ɔde bu ano for ebi ne circumstantial evidence ana ne fia dwo so ɔne ne ba pie ɛkɔ afuo mu sɛ sɛnti ɔba na ɔde ade bɔ ne tirim ku no na obi ani hɔ but he was the last person a ɔde ne ba ne yɛ den ɛkɔɔyɛ nti pieces no ana court no keka bɔ mu na ɔde bu ano for nti yɛfrɛ no circumstantial evidence, pieces of information that will lead to irresistible conclusion. And ya na tai wo adwamamom se bia obi ne yere te no akobo adwaman na atada wo mfa wani hunu ba be hwe condom ne ne ma bi egugu or pieces of information that will lead to irresistible
hono na evidence so obi ne ye obi akoda
obi akoda
wo hunu bi
ba dem condom ne pants na otai use evidence nketen
ba wan
sheda hunu to ke kan bo mu na ade wa adwena hunu se ene na ye won that is circumstantial evidence so we want to me charge ni nyina na circumstantial evidence no didi asem no and odibu anofo no and so why evidence act no
okay but we share a judgment no per judgment no ne judgment me I mean to me enkomu in full yes my kind kakra but assembly nyina no sa circumstantial evidence here what can you say you know ebi ehunu say akonta mining yes akonta mining ho ebem but no a corporate here a bit to sealed and it can be sealed.
That is so.
So the question arises from some lawyers say, are they and ye rule in chairman want to be as director of a company now director of a
okay that's it. You see bibi a friend separate legal entity principle Solomon versus Solomon. And two months and a separate legal entity, it means that the company is separated from its personalities. And the nipa no moye adwuma no separated from company na Nkansah. And the company na artificial person. And a would nipa na oda no ye natural person. And the company speaks to the natural person. The artificial person o kasafa nipa no home a enkwa wonu mu no efa no mu. And the opese o se company na ye bone a obetima twe company na so. And as emra no pesa o twe directors and so I afraid be lifting the veil or piercing the veil and to be lifting veil no adrade na she company no be lifting no or lifting na be hu nipa kora company na ya na de anti asotwe ni bi wa toda utimi de bi ma no yes and you will be a friend no lifting the you see my case was separate legal entity principle separate legal entity case me as Solomon versus Solomon SA Solomon versus Solomon. It means that a company is separated from its personalities. And the company no is separated from the personality. However, I thought that company near Bonia ultimately punish company name. I thought that would be all punish company, but that's punish it. Any punish company national. Now before bit me who no be lifted the veil. Na veil no bones were ye adradren veil ne ya de se nkramo for the show meeting no ntu pagya company de adren na hye no wa behu nipa o hyase ohu de o hyase then you will see the directors and punish them and that is why our lifted veil no wa punish director na
but okay we shall get to that
let's sa director no wa be punish whether or not say emra no man kwan say sa director no punish no based on that circumstantial evidence na court no hu ye necessary punish na ni kwan so punish we shall look
all right ho nyina na biyanhwe and the minority MPs no raising so maybe our base maybe the can share everywhere and then omo problem number 1 yes case no ne lawyer anyhow na omo ebua asem no and no judge for be because na no the country and I say be in country baba kwa sa account remember work by lawyer you know ba kwa account bi edu baby a enka lawyer obemu no se court dey asem no ko Supreme Court obo ampene wan fanko na be dem say edu baby kra no and the appeal could be yes or appeal on some grounds be no squad obo ampene but the lawyer cry bemu a oduni masem do so oba be hwe be nko okukuru dia ko Supreme Court and also omo ampene no wadwenkyere ene say
yo me da se ho no ye wo Supreme Court decision ewo ho you see na echinege no section 99 2b section 99 2b no eho any article 1911 all offenses must be defined and the penalty for it must be prescribed in our written laws. So only article 1911 all offenses must be defined and the penalty for it must be prescribed, and it's section 19.2b. Section 19.2b of Act 703 no actually say o the assignment or assigning mineral right the amobia as I say in writing. Say in writing there any na or say most of the assigning right ne the ama obia different na sa right no de akwa obi no or Troy enya written approval every minister no one answer when nya written approval BNT I was say conveyance no the baby mo obi akoya adwuma I was say ochrogu krata so enti hono na no mo de yes eno no na chese nya offense bi a ya be define say punishment ye say and it's not in writing and it sins against article 1911 of the 1992 Constitution of the Republic of Ghana. Therefore yenko for further interpretation of the law whether or not say section 99 2b no Act 703 no was all the conveyance no the assassin mo bi ayeso adwuma as I say in writing no yen sa de no nya den enko yen hwe se yen tro no nkwan manum say yetimi de punish obi ananti yen fanko Supreme Court for further interpretation of the law eno nana omoje ehun achinyi no enti eno no already authorities like bibi to say the case where already Republic versus Nkansah Supreme Court decided Republic versus Nkansah. Now already the case of ex-party Senator Rollins we say now already ex-party Akosa we read these are 3 cases where you understand it we say Republic versus Nkansah any ex-party Senator I can't say judge na Nkansah asem na ba wanim no say wo hwe na say wo hu ne say there is no ambiguity na what we say ntiase wo mu a obetima to aso aye wadwuma and the judge na rely on that is Republic versus Nkansah and the ex-party Senator Rollins the asem court no na yi nya asem o mo election court ni decide but already ex-party Akosa Supreme Court decided yana eno no edify kakra from Nkansah Republic versus Nkansah ne Senator Rollins case no ubon se eno no de kire ne say letter bi anase construction bi imprecise ambiguity unclear anase rival meanings have been placed on it and tiase ni mu a we ya jaja was so otobo na wo hwe all the pleadings no holistically and some na beda wani mu nyina obehwem na wahwe issues no mo de beda wani mu nyina wo so hwemu na ansa na was satisfy wo ho na wo said there is a real question ebia e was say a call for interpretation there and ya wo judge ne mento aso but sanfa ko na refer matter to Supreme Court na nka yemfa nya adwuma nti hono na me rely the case of the ex-party Akosa as a ex-party Akosa no there was a rival meaning no mu say ambiguity o monte ase asem we ho ntitobo menko Supreme Court and the wheel of justice no the wheel of justice no it grinds what slowly and the wheel of justice no pepe no wo hwe ne tie na de adwuma na ekọ kakra ansa na akọ so the wheel of justice grinds what slowly and so they do obi say onya abotre omo no feel say there is an ambiguity so I was expecting the judge not to rely on ex parte Senator Rollins any Republic versus Mekankan decision no but nanka me feel say bi anka otonobo no hwe akosan de animu or hwe the whole pleadings or hwe issues no or satisfy no ho ansa na ebi kura anka otonobo no refer ekura no ama time kakra na Supreme Court in decision abanka betimi abo but baby any why hono judge na wrong because a decision authorities and so feel say baby or rely no office say ex parte Senator Rollins and the Republic versus Mekankan ebetimi aboa de ntina ma otoaso however maybe their judgment na mu na me ba beko na me hu ne ebi ame no so far me nkan ni nyina nsi ba baby amedru ne de me hu ana me pesa meka ahun say so hwe prosecution witness na PW3 no your police chief inspector Safo Asiedu ana ode ne baaye wo PW1 that me can PW3 a prosecution witness number 3 out in the buyer PW1 prosecution witness 1 Okum I am say Henry Okum and all kind PW2 now or ye Jedu and or do buy more do be dia dance no now but say a dance Okum no or person say Kwame Antwi I accused person na otosumi no Kwame Antwi ya bono kwa adu aka wontumi ho na won se akonta mind we dwane no ubon se na Okum no pese o kire se Kwame Antwi ne na ye den ede ehɔ no ma no na Kwame Antwi no ede ma ne se wontumi se omunko reclaim asase bi wo hɔ no na kye se asase na asɛe no omuso omunko dua kube na omon reclaim enti so wie Okum a na ne kasa o court wo nyina pɛkyɛ sɛ sama wontumi ne kora no no amfa na ni nya den anke hu ne da just TV so na ɔde hu no ɛne ade what ya say ana Okum no san kyerɛ sɛ sa company no ɛyɛ adwuma konta mine no a ɔmo no Kwame Antwi ne de ɛhɔ ma ɔmo so ɔmo mfa nkɔyɛ adwuma no na ɔmo yɛ shareholders a ɔmo wɔ company ni ɔmo yɛ directors a ɔmo betimi se gold bi bem ya ma mu bie eye wontumi mo aha enti ono ade onfa na ni hu ayida ana omubusa gomashi another I think say PW4 as a wisdom gomashi
only expert
yes yeah. So wisdom gomashi so ba no say mimpo mi so wontumi ni minimu no nemu Okum Henry Okum na beka kire me say chama wontumi say asase bi one na de hɔ ama wo mo sɛ omonye ani ebusa Henry Okum no so ono so si wontumi na akra de ono wo hu no the first time ode hu no ye TV so na kyese ni nyina akɔ chama wontumi manager na ba ko na efre no Kwame Antwi no na kyese Kwame Antwi na aka akire wo mo enti wo hwɛ saa witnesses we nyina ana ye di police ni ebaaye ana police ni a PW3 na obedi adanse no PW3 no so kire mu sɛ ono de wontumi ma omote se galamsey bi nkrofo bi yeden ye galamsey ho den sase no sei wo ho ene ade ma omo no tu anamo ko hu se ho se ma omo pam omo agigi omo mfidie nyina wo ho enti it means wontumi report case to the police I say illegal minors bi ayeden aba ho enti we kura na ya de a kire se wontumi ohun se de ekoso no enye na the issue before the court and say whether or not say statement na a PW1 kind, PW2 kind, PW3 kind, whether that statement is a statement that can be relied upon. Whether or not say, sa issues now at that court whether or not some statement near hearsay. Now, if you read the Evidence Act, Section 116 and 117 of the Evidence Act, no one has a vested right in evidence. Obi anu a woni die nkwa right as evidence nkwa nanim but pursuant to section 116 and 117 of the Evidence Act no akire say hearsay evidence is inadmissible. Take akire yanyentum.
Hearsay evidence is inadmissible. Okay. Except
hearsay evidence a border on family issues, traditional issues, any other and nkwa na betimi age atum. So yemfa ne se me nana no mamamre otumfo otekokko so mesra na ne die de kasa omo amamre ene kwan omo fa so asanteman be ye omo dia o ka dia ne de agitum na busua me fi se na ha na ye sie ye ampa wo be ko dead body nyina ho ene ne agitum apart from saa nneɛma we so historical events are yatia kan kyerɛ wo nananom ɛka kyerɛ wo abusua mu no ne nyinaa de agye tum na mmom apart from saa ɛno no te ka kyerɛ bia yɛgye ntum enti hearsay evidence is inadmissible section 117 of the Evidence Act. Now obaba behwe saa enipa miensen a omo ye witness omo kase a omo nyina obi ase te kan kire we na ka kire me se chama wontumi na ka ase enkoye adwuma ho we na ka kire me se chama wontumi na ka kire me se man Henry Okum oso ohun chama wontumi ekra no no ma obi na ka kire ne se chama wontumi na se omo nkoye adwuma no omo reclaim eti ho no ohun se atene general ne busa question bi obusa Henry Okum ne se sa ose chama wontumi ene kan se reclaim asase ne dia oma usika fa koya asase ne ho adwuma reclaim ehono na Okum ne ka kyem se wa ama misika bia ana obusa ne se ene na kwan ben so no fa so kan asase na asai ewo ho no ko reclaim galamsey fo asai ne nti ko ne yensa nya asase ne back obusa ne sa question no that is attorney general Asrem side we Asrem side busa sa question no enti obusa sa question no ana Okum no ebe yi ano se wa ama me kwan se wa ama misika se me mfa nkonkoye ana obusa nse de kwan ben so na abefa so ka se mi nkodua kube ne ne ma wo ho eno na me de omo ka kire me ana obusa ne se na se sa de wa ama usika na kwan ben so na afa na ose me de me ko ho no mi se ne ho no bodu wo ho ana me start say ne metubi nti metubi na me ton na me nyaska na me de aba be reclaim asase no look at the statement based on this ana judge ne se ene ne ohun ne se o chama wontumi ene ma akwane kwan ma ne koye illegal mining wo na bia maka ya duru no ya medical hu no enti me de baba to issues before the court no ho a na me baba be ka say ene se ohwe nipa miensa we eye atesem we si we na ka kire me se chama wontumi na ka asem nko we si we na ka kire me se me kura wontumi me hu ne da na asase na ase ne ase nko reclaim ne anu akube so instructions of chama wontumi ne kire se monko na monko reclaim asase na monko dua akube wo ho de a ene na dien ene kan wa wo ko ya okokoye illegal mining se enu na abenya sika na ade dua akube na sika no dua akube na wadua akube sika dodo sen na ehia ade be dua akube nti o se wo ye illegal mining ansa na ade akudua akube no enu na me cho say hearsay evidence is inadmissible but hanu mi huni say court may rely on the hearsay evidence enu ne circumstantial evidence ento some medical ka cho say circumstantial evidence here the whole trial is circumstantial evidence. There is no direct evidence. A pieces of information and a prosecution gather that will lead to irresistible conclusion and nothing more. That means that pieces of information that will lead to irresistible conclusion that you but no other person will do that. And it was a pieces. No, I can't boom pieces now by a thread and I say a rope. Now boom and son what immediate a convicted. There is no direct evidence as to whether or not say won to me na oye illegal miner na wa sign and on busa say na right now also wa sign the amount no e was say in writing say ye wo ye nyina ye nim say so bi di na say ma say koye so adwuma on the book rata so enye na no kwa na aka cho say we kokofa because it borders on conveyance in law because I mra na ye ka enye amamre sem na say ananse sem na ye to in law ye ka say conveyance conveyance a transfer of title me transfer of title at the ma conveyance into law school part 2 exams you free be conveyancing and drafting drafting that means that a title of the land now will transfer the amobi so that title of the land of section 2 of the conveyancing act say it must be reduced into writing I was how the good character so answer section 2 of the conveyancing act. Additional section 2 of the Conveyancing Act of the Ghana law no, it says that say any transfer of title there must be reduced into writing. I was saying with the good characters. And when a lawyer attach say one firm characters also were from section 99 2B no and he found a war SSOB from na a characters were say any panel from bra and yanko for further interpretation of the law. Because all offenses must be defined and the penalty for it must be prescribed in our written laws. By virtue of Article 1911, Bonibia person didn't pay and I was say a chro. ewo nkwa nwoma num meka nkwa nwoma ye me no me nkwa nwoma na mebodi ne ewo ha ne the 1992 Constitution of the Republic of Ghana ene ye statute books no in the sankoma nwoma 19 nkwa nwoma no 1911 no ehene fa ne atworo se so bi entro sa de na ontro ya also with the convict say yanko for further interpretation of the law ehona na boda o kan say why stay into abaning fa a court no fa na assembly to na on refer matter to Supreme Court for further interpretation of the law. Now you know say Supreme Court of 5 main jurisdiction metai kan wa 5 main jurisdiction ni tumi no eye ne manum or interpretation otimi ekyerɛkyerɛ mrem or review ono ankasa timi review ni decision say ene me na me kan say Justice Tokuno ya sake no ya gina article 146 so ene ade chia ya de justice bia bo no de 146 ni meja na manako etu be kaya jaachi question o kai say na oye dual okutadua citizenship no ye Ghana ni sa ye Canada ni e ba say ono court jai no enso ye nya obi wo Ghana ha no ye MP a no free siremu a nantwie eka ehwe so ni ede ne court saa me no ye Burkina ni sa ye Ghana ono de ede ne kokotum Supreme Court na asa bedane na no ewo jaachi kwesi no because of omo review jurisdiction ewo ho now yes how ba kwa friend supervisory jurisdiction omo supervisory jurisdiction is omo supervise court bi ahwese de uye bia da na kwam ana omo san wo exclusive jurisdiction yes say omo nko na assembly wa mutimi di obi antimi ni bi ebi ni say president achinyeje ba ho a presidential election petition omo tumi ni bi no enti interpretation no omo de kyerɛkyerɛ mra nimu no article 130 clause 1 and 2 and article what and then article 2 clause 1 ujina so ansa na watimi evoke original jurisdiction for further interpretation and the honor obeba bibia your friend no say cases like S party Senator Rollins Republic versus Mekankan hono na no kire say eno de judge ni hwem na say judge na ehunu say entiase wo mo betima to ana asem so but S party akosa na ba kire say there be we judge ahwe issues no whether there are rival meanings whether say there are imprecise ambiguity provision here unclear entiase ni na chinyeje wo ho de atobo never assembly refer to Supreme Court for further interpretation of the law.
It's going to be a long day, but yet, lawyer Evans Osei-Bonsu, and or children same. Sometimes it might sound a bit technical, but fache we a court demo brofuni be no old children, but what try also or breaking it down. Na layman also no what you say but don't want also no be so mo etiase because emra no mokoka no e wo court dem ho enti no na lawyer e breaking it down e de amaye wa hado ene awie yakoba ensempi wo ho a ye besa ebisa lawyer besa obafidie no na ha se ya na make say so no honorable Francis Edusipoku and so honorable Edusipoku so former DCE for Esnafo South area just no yes ukra law background enti honorable area but Francis honorable Francis Owusu MP for Jabin constituency. A very good afternoon to you, honorable Francis Owusu MP for Jabin constituency. A very good afternoon to you. Enti me ko honorable Edusipoku enchen na we no de adu ram ranum na fe ya na questions pi wo hodoma ye baby santi me ko honorable Edusipoku enchen na me say honorable me ma ko aba net to say
nyamiado
honorable ma feel papa said and say me show say about no dey na am de ho jiminti na da agini posukra
polling station eja edika no mame mbo Sunafo South polling station executives ne literary executives ne constituency executives ye yo me bo bi abaso the adwuma no asase ano no obi anyere no no nya adwuma den afi menchia obi biara awofo ne asantema obi a wotie hwe enewe bi ameche obi a
obi ajoso honorable me asema aba enu na nkyɛ sɛ Black Monday yɛbɛka no sɛ Black Monday ɛnyɛ asɛm ketewa koraa, but it's all about Chairman Wontumi ɛno a deɛ ɛkɔɔ so yi ɛwɔ ɛyɛ Justice Kwaku Vitae court outcome no ɛde yɛadwendwene ho ɛnɛ awia yi.
Okay, edi kan no maame sancha mu bio ɛno asɛ deɛ ɔka ne nyina yɛ ante asɛm de ɔhwɛ nkyɛma ananema ɛkɔɔ so ɛyɛ high court presided over by yɛ maame Justice Audrey mɔde obuatan sɛ yɛwura Chama Wontumi ɔnkɔda mu mfie aduonu na no krani nyame anim ne no ayɛ nyina yɛbɔto yɛ sɛ bio koda prison 20 years deɛ ɔtamfo koraa no on we sisa deɛ no ɛma no nti ade a ɛba yɛ nyina yɛbɔto yɛ na yɛmu bi judgment no from page 1 to 59 nyame adom yɛtimi ahwɛ mu nyina na no krani nyame anim ni edurumre bi a ya maame no ja on na ye judge dia nanso so sebio judge for na omu judgment ba bontia yesu yetimi kasa ho kakra sebio judgment ba the only thing I will be my answer be appeal no tie enkoma course no a kire se party no any lawyers for Chama Wontumi I initiated the process number appeal the judgment na minia edi kan MPP as a party enemy a discipline committee se bi obi adensa kobo oman ni sikam ana se bi obi kotomra se bi eye esembra ni nedi obi eno obi defend se bi obi akodi bone enti chenchina ye bia oye party ni nti no enye semra ni nedi nanso so keke no kraye baako edrum bia e kamea is who read the judgment no from page 1 to 59 e kamea is Chama Wontumi case ya be e na no asembintia keke ye na no asembintia because every lawyer bia no se unya adaje every di ade no ya di twakosi ya ne se bi obi asema waka eno na ye maame no ele ni bibia wo so e de bua Chama Wontumi fo na de areho ne se e criminal trial minia criminal trial no so the prosecutor no you have to prove beyond every reasonable doubt in this doubt kakra bi kura ba mu a na kire se yi kura mu a enyi na minia de enti na make se asemi yakọ na anu asembintia hwenche June bosumi atwam no I think they told me answer NDC activist back I think we empenfo no back pie near metofil or try bibi do to Facebook or try to the or try and say o say Chama Wontumi de watete free ne boss for no ene de watete na kire no wonim pefe say Chama Wontumi the rest of regional chairmanship adwuma no obekwa akodi no ansawam kire se wotie nkomo wo akiri wonim nkomo a watie o kan na ani ke ena edugita makulu MPAC was I NDC legal team
yeah
ebe tire wa asese masa delay this
exactly I mean who supposed to pa
ana obeka je ni amadefio say delay this kire se masa wo wakwati asema na obeka na
obeka
ho no delay
speed as you did post to
na odile che no onim say ya screenshot de ato no ni say screenshot ya de no e de ato enti uhwe de eno na hwe ne ma bi e course a eno na ma binum twetwe binum adwen si say semi de e yakọ se hwe aye na no asembintia bia mami mfam free ni say one Chama Wontumi ye de kwadu makomakun sia na ball no Nkansah nsia na de ball no de convict Chairman to me de toso miensa ne de toso nsia de emrana de convict Chairman grounds ni nyina charges ni nyina were grounded in the Minerals and Mining Act 2006 Act 703 as amended by Minerals and Mining Amendment Act 2019 Act 995 saa eno emra we so enye ginaye de saa ntansa mienu no ebo Chairman to me de toso count 3 and count 6 ye de bo Chairman to me so nko den fiase mfie aduo no minia de ba ye no we read the judgment ni nyina from page 1 to 59 and can be bia say Chairman to me to galamsey. That is a fact. I say you will be added to na dream. Because when say ye nuanum bi e the propaganda bi en na mochire. We read the judgment na be bia no a judge ne kan say Chairman to me to galamsey. Na mom sebi ye maami Audrey Nyansa mu no. Chairman to me e de na saase a wono wakwaji ne legally wafa kwampa so akwaji no from aban no. Obi akona saase no so akotu gold akoye galamsey wo ho enunti eye Chairman to me na ama nipa no kwai enunti yem fantas anye de emmo no asem ni nyina ni na you see me the best at here free say me okay the 1992 constitution article 19(2) FA a class MB it talks about fair trial and any say minia say they assam to be so especially in a criminal matter so many nipa no kwan no wanya lawyer se bi obetimi edi nanum atwitwa age no a very fundamental eno see ukaya Chachukikata versus the Republic yero Chachukikata se bi court ebu ti anu se ready for that was 2008 am papa no kodem Satam yewa omampanyida da akufo man even a presidential pardon. But Chachukikata say on tiase still now no sa judgment na ba ya man ko dem no be appeal. And yewa Chachukikata appeal against the judgment. One of the reasons until we appeal against the judgment ni say sebio ni lawyer o kan ho no. Ya man kwan man lawyer na anye dey am ginema ndi bia ma no. And at the review application no appeals court no omuka say no ne access to a lawyer no a very fundamental enti kwan bia so saa ayi na judgment na high court buati a yewura Chachukikata no omugi tuma enyeyi pepacho yemra come fast forward yewura Chairman to me yewura atachia ene bem sebio yewura ndi apia ku bi konchen no ebe mbe take over the case yewura atachia enya akwanya akwa outside wo ko diasem o arrange on calendar so dada ena ni client sebio da say ye kwa akobu na ten ena yewura atachia twere letter e de akoma sebio court ni say osere wo mo wo dwumadie bia wo kodi ni wa abonten eti komuma ne kwan no mu ntwa ne nyame adum no obedura na wagina ne client nchen no mo court ama se be de court no bia o maka court no so mugituma enyeyi edi mpacho going by this no na just a president na ye set ye in Chachukikata versus the Republic no one yabogu yemfa no ntonche na yemra yesi Chairman to me criminally liable me ba cho lawyer wa ha eje de afi ni guso mekai statement bi a Justice former Chief Justice Kosa ekaye in Commissioner of Police versus entry sabio so do bi kwa asem dibia in a criminal prosecution the onus lies on you the prosecutor no to prove beyond a reasonable doubt
say indeed enipa no Nkansah na wode bɔ no odi fo though PA former Chief Justice Nkansah kan Commissioner of Police by Sentry which Evidence Act na 1975 section 15(1) NRCD 323 na enu so wom. It is established say the party alleging the crime, that is the prosecutor, must bear the burden of persuasion. Who now be prove say indeed enipa no Nkansah na de abodo no odifo. You see, we betimi de asemato e bia meme so. Metimi akokot megina ho aye wo asede say obe prove. 1, the mens rea. 2, the actus rules. We be prove say indeed these two elements no me ebu me for enunti no sebio Nkansah yemfa momme. Ye we chama wontumi ade ye baye. Kege me na makwaje masase chama wontumi akwaje na asase. Court ne say chama wontumi fa akwampa so e na je ne concession eno de efi bia ni ho. Ena chama wontumi ade ama entry Henry Mr. Henry say wonko reclamation emano just wonko siesi asase no so emano no siesi asase no so amra ne ade nyina wi a wadua kube wo so de amano ena Mr. Henry koye okoye no yesi wo tu fo magudie kire se okoye no oye galamse wa asase no so ena police for April 2025 security service ni ko ho eno mkwachi wo mo omkwachi wo mo no ena nipa no mo chim ni bodi say Mr. Henry na mo mu kwan eno mu di say adwuma no wa chama wontumi asase no so de di kan there was a witness utie de lawyer kan na ono oba abonten ka say chama wontumi kura te say sa na ma bi ko so ama ni ba police for o mama ne mo mu ko so kopam wo mu de di kan e kire say chama wontumi ote yese sa BBC ekoso na asase no so no se bi otu hwana mo yemfa no ntonche ena yakwachi nipai ene ade o makokot chese de di kan chama wontumi a won concession de onkodi nsamoni bia won concession no so eye Mr. Henry no ene o ma no kwan se onko reclamation ene afa ho ene o ye mining wo so. Per the judgment in a buyer no. Anyhow, what the prosecutor go about with this case, you know. Mr. Henry, they see a John Uncle Van Huni. On your bonnet. There were no one say assassin. Essay assassin say, Sua. Eddie Bono assassin, so no. A buying say on Van Huni. On your bonnet. No mum, the na assassin or the man, Mr. Henry, say, on court no queer reclamation on your cubin, or no more, dear, you're jailing 20 years. Na yekase asemwe ye nanu asemuntia
political prisoner
untiase asemwe enye nanu asem na enka asemwe yetimka Mr. Henry no aban si onkofa no huni wonu mo bedi adanse ma aban no na danse ne sei na danse na wodi ni sei chama wuntumi ka kire ne sei wonko asase no so na wonko tu fama gudie no na wotu ya sika no obenya afiri mu no onfanko ya reclamation onfanse asase no so no onfam bi nwe kube no asema Mr. Henry ni kani ana chama wuntumi si dabi media man kan kire ne se wonko tu fama gudie na mo me ka kire se wonko sie asase no so me ba cho ayedi se ye nyina ye swear under oath. We were some against mine. There is no official document because per the last act, you know, who are signing land amobia, there should be a document to that effect. There was no official document. There is no direct evidence. Say indeed, chama won't me catch Mr. Henry ni say won kwa asase no nkotu for magudie. Yes say, asamna Mr. Henry kanu. Onu mo me agye di enu nti chama wontumi enkodam fie duru adede ebone ede ebone Meaning, say, this when it falls flat so far as criminal prosecution is concerned. Because in criminal prosecution, you have to prove beyond every reasonable doubt. Bibacho, kege oto, na say lawyer kan asem, me so maka me de. Kire say obi awo asem awaka, we ka bi. Na say wudina lawyer de so, ka say de lawyer kan me de, eye no kura ye frenchim na eye kroje na me de untie hwe a. E chese we buntantia. And in this case, now say we prove beyond every reasonable doubt. And this will be because asem we there emu owrem na ya kamera say na no asem binti ene ye chama untumi say odika Bebacho, going by the logic of the case na ba no of the decision of the court na ba no say oba your constitution mu a Article 257 clause 6 say ya good ya organ ha nyina de ama Ghana mampanyi meboa Ghana mampanyi na we so meboa ena Ghana mampanyi bro don drama ni ma baaye no wo kukuru da ma mines e de ma ni ya Ibrahim ama meboa me dase ndimbacho se wo kina bi aban sesa na ya Ibrahim ama tenkran na da ma mines wo ho na ya beti se ya se galamse fo bi I am quoting on to damai concession no mu to galamse a kire se yetimi jeli ye wa Ibrahim ama mane Keke mi bisa so no.
Oh, sa de ye twa to.
Me de e lo asem na me kan. E kire se e ba ni sa yetimi achi ye wa Ibrahim ama jeli no mane yi.
Ah. E kwan men so.
Okay.
Enso enese sa na mo ya kire.
Me ti afo. Afo mi we e ho na new month concession wo. Ko Kenya se. Every blessed day new month apamo encroaches. A mobile be a common sass in should be a to galamsey. Going by this judgment, Tresse, Sabio, and Mrantian or more quoting human land, no, I will be a galamsey, no. Say any criminal liability be about as a quoting human. Bebacho, Mrantian, this Mrantiana, Omu, you shoot to more bossy. Ama Omura say I am global concessioner. You shoot to a mono, a dimbacho, Omubaso Mitresse. No esenka anglo no abai echi anu company no o chimpanyfo ni bom gum because o masa ase so o ma allow my encroaches ewurom edu galamse. Is that the logic? Na dia na ekoso o maimu
what
mi dia na ekoso o maimu ada Ghana no sabio ya chichiri dia ma yewura John Dramani mama say onfa na the speed ya omodi adisa yewura chama untumi asem we no mibisa wo yeni anu man disifo na yewura John Dramani mama na ase ne nkofo no mutu galamse no me ba jo masema ko sisen
yante hu hwe
me ba jo
yante hu hwe
ya wa ha na Attorney General ye letter edi koma yoku in the letter was say we establish a primary facie case me ba jo lawyer kirem si ekase ya obi kase lawyer ni ka tro say we establish a primary facie case say
first instance
just we won say bibi ya dai ewom say yewura ya mi Nandis national organizer ni Nandis third vice chairman abanga wonu tu galamse eburu 1 year what won asem
dabi
me pa cho awe NDC MP o ha na awe himfo etwa moja gudu say o tu galamse me pa cho keke what won asem
dabi yante hu asem
keke ya wa ha NDC amanfi west as amanfi east constituency chairman beka say ni DC etu galamse what won asem last week ya wa ha ana afano south ehemfo every NDC MP Yakubu any NDC DC o ekwa invest o mu say o mu say o mu tu galamse me pa what won asem
yante hu asem
ya wa ha ana NDC DC o Boakwa south ekwa parliament wa appear before a parliamentary select committee ekachi o mu say ni chairman ba etu galamse o Boakwa south what won asem e dey nyaachum na ekoso no
ya original minister not excluded
ada ekoso no
mate
e dey nyaachum na ekoso no na sabio who to obi de yam fan going by the logic chama who to be kra de sabio emra ne a kire se wanyu onu na akotu wono de yes won kodem because na sa obi akotu so na mi bisa de wonu ankofo ba be kase wo mutu galamsey na and de wa ma wa mu dai
Honorable Bamema ahome so honorable and seminana all kano and semina and all kano and yes selective justice said the honorable kano be kwaye bonia and no yes so but the issue of selective justice said the minority MPs no air kano and no any problem no e be examples are honorable edisipoku so edigu wonomi yabekwa yedebda ya hwe yabeche time no egu so later on or till end of the program ya the gasto mixture but memra lawyer in China mesamba honorable so lawyer Evans Osebuns going forward say baby yedru no part no agya to say say no case the Becca says you are nice Nkansah. Now even before part to the Begia to do say honorable and the appear could be because at the point lawyer Abia one Pemno Paya but now said ye may be air lawyer really felt uncomfortable. Now ruling no ebairo but who should go be the honorable and the appear could be say or no and well lead the chairman would to me to the slaughterhouse. But without necessarily going into it. ABS, I don't know how, but don't wanna the any time or the pull out. No, and surprisingly, they started say lawyer and the appear could be say chairman would to be so lawyer. Maybe lawyer, lawyer, but maybe the tough about say a yemede says he say party no see as no Nkansah assume, but lawyer a backwa appealer. What will now be the grounds for a appeal?
You see, yeah, will be a friend omnibus grounds. And Tiano Nabons a lawyer for actual accused person or aggrieved and dissatisfied with the judgment of the court. And the omnibus grounds no and Yama Ujina Swa and it will be once applicant now or appeal or dissatisfied with the judgment of the court. Applicant na ya aggrieved so dissatisfied in the omnibus grounds and udi kind to be the kind of omnibus grounds no aye appeal answer because I was a bay pending appeal. Your bay pending trial and your bay pending appeal. Trial na your time trial ni gusu ne bi edi ni panashim ba we a bay pending appeal because you di kind incarcerating na you na kotumo ensa wamti afi na obeye bail Nkansah na wadi kind na bansa na da but be no be ya ebeko court of first instance no that is a high court na odi na asem na ho say ho na ade be ne sanko na judge ni hwem so be ma okwan na o ma won kwa ndubon se bi wa judge ni betima hwem no aka say ono no ohu ne say be no kra no na judgment no de abaye kama ntu o ma okwan ma won ko be no dismiss no enti obetima ka say o ma be na still
it ebeko justice Kwaku
hobiem aha enti akono hobiem a you see, economy but because I judgment in Intino or 3 months within 3 months to appeal. Say interlocutory judgment there and temporary interlocutory judgment they are ruling. Interlocutory ruling there are 21 days. A be normal cause submission of no case. Submission of no case within 21 days one appeal here. Let's just say a term. But when a permanent judgment no there meant I was said within 3 months no ubetimi akọ. And no crown police we visa 3 months now also our additional 3 months about 6 months 6 months so no one called the natural say and one no and no crown oh kwa I was so called say 3 months in pound will motion for extension of time within which to appeal. What has over filed is the motion for extension of time within which to appeal. Then no kwa the other side because record to say 3 months in a beating. And now when you are be a ball lawyer now you are be a see engine went me ama it what we do right in the about record to so mobile no some for another 3 months and count na court ne grant ma and on natural say but you know because you see that thing you na court mu nti or be pending appeal as abri wachina kura mbetimi dia tumbat
say e bi omo man bail
that is so
okay
enti appeal no Obama court next day now the appeal notice of appeal now the atunto the court now justice ni hwem now ama okwan you can repeat the application at the court of appeal. That is first of all they are call of judges most often also the corner ni mabonso wa twam kura wa dismiss no that's all no fee said the judgment or the by okay it all ma kwan but yes announce where you were then why repeat application or court of appeal into the court of appeal and Nkansah form and on the ma kwan to don't so mama kwan say appeal na fi what the appeal na betum na say what the corner records of a in na say what the court appeal
it's where you can bail pending appeal and no the senior can a trial judge na obehwe say
baby cashim e o say what the court answer no ma kwan answer na wako na wa ma wo kwan mbara ne san kire say obetime repeat your application wo Nkansah form yensa no court of appeal what you say nti nyansani na odi kan no de kɔ no ama kwan na de kɔ Nkansah form yensa no enti eno no de kɔ mo a ombetimi ene ye friend repeat application enti na de kɔ wo de kɔ ho no ma ombe ma kwan omo ma kwan na de abeseve no sa afi de ama kwan 2 copy afi na no aye obi bia wa pin na de records of appeal ni nyina aka ho na wo de atum enti afi na Nkansah form no kɔhwɛ ade a eto sini ewo ne judgment no anasa fresh evidence bi ewo ho foforo a wode buy a court na vet ne mind ankoso ana a ebetimi any to the benefit of Kyeremanteng and na court ne kohwe anasa ne fundamental human right bi ho infringe and a key issue if the fundamental human right was trampled upon a court no be kan hwe no ebi na ne ka the case of Chachuchikata versus the Republic no at the time the judgment was delivered not the lawyer ni ho what I say I no can so stress your man lawyer mra yes so judge ne kan chan say wo the asemo ba da bia be camera say woni mra wa ha na ne de lawyer ni ho de a wo twan say lawyer emra o lawyer wo ho ni ho mebua eto obua e no owura Chachuchikata eko appeal no but appeal no so but no you so wise very wise intelligent man ti appeal wan kon wa MPP fe epenso regime oko appeal wa NDC tam NDC ba na oko appeal no what I say and justice Dennis Ajay eja na man koye I'm not saying say ebia my question ya na mbusa mo say die ntino owura Chachuchikata sa tam wan kwa appeal no time MPP regime I ho because ya nyina ya ja lawyer for ne judges ni didi a any date na wotena wa MPP amemo ende ye ansa na wode appeal no e kotu wa NDC penso so you should have applied.
Seven kono kranka omanpanyi kufuo nka or pardon or so there be obe fight the case.
Yes, I know yes on some kono omanpanyi kufuo so into to me me try say me dem adwene na e kan to me naturally say onyi ni say judge for oni nyina that time obenya pepepe ye and this say a tangent to go by there and naturally say ebetuma basa wo kwa PB na kura nso a wo usuro if it's a binary what no unanimous FC on also for the Supreme Court no. Now if you read the regulation 33 to 34 of LI 21 I think let me maminko to me ye na manfom. So when you look at LI 2182 once there were law be a government year minerals and mining health safety and technical regulations at Minerals and Mining Act obeshema section bi on my regulation 33 to 43 ubonse of LI 2182 ubonse eno no e kire wo se wo manager na yade environment na ma wo na wo so obo environment no ho ban enti enye the leaseholder so the law takes hold of the manager managing the environment enti a company na ya konta mining ana ya adwuma sa konta mining no manager na wada no e wo so oye obi a oye expertise or knowledge our environment ho na obetuma protect environment no e de se bi mfumso bi ba ubonse regulation 33 to 43 of the LI 2182 no ubonse eteki se nipa na on our manager no rather than the leaseholder aye Kyeremanteng to me am fancy amani lease to operate and na me hear discussion the na bi no kan say Kyeremanteng me akoya galamsey and ntini achi no that is not the na ekoso and it was a very renowned radio station and na no my discussion in fact I call somebody and me name no radio station was
propaganda yes, show host TDB and a whole daily graphic show headline
and more to the point no discussions like this no edu baby ya mra ho asem na ka if you need a lawyer to explain it you understand that you can bring other panelists on betima babeka ho enti e was all the lawyer from so that the lawyer will correct some of the mistakes in it because a law ho asem na ka and a judgment na aba somebody has not even perused and me I disagree with people who are even equalizing say okay the mere fact that NDC for so you be no dey no dey enkoche wo that is not the issue before us the issue before us today and it's whether or not say judge no the pay ni di Kyeremanteng to me and whether or not say Kyeremanteng to me aye bonia e was say de ko jail now. This is what we need to peruse. Now peruse you see said the judge was relying on hearsay evidence. Take catch we na we catch me and pursuant to section 116 and 117 hearsay evidence is inadmissible generally inadmissible, and I'm saying that no one has a vested right in what evidence obi anyone ma or perfect or evidence him, but my law tells me that pursuant to or by virtue of section 116 and 117 of the Evidence Act, no, all hearsay evidence with exception of traditional evidence generally is what inadmissible. Enti okum and I can't say me chama wuntumi kura me hu ne da media TV so na me hu no we say media we na catch and say we so okum na catch and say all the prosecution witnesses ni nyina no or say we na catch no, so the judge should have averted her mind on that hearsay evidence. What you say me kan judgment ni so baby amedro ne de baby na me hu no me hu say that hearsay evidence is lacking. Into a basis are obetima catch judge no ho. So you need to peruse the judgment. Every point to be a judgment in can be a mrano. We will say one averting mind the judge held on point of law. That will be your grounds. And never be your grounds now the beko appeal no. So what catching of hearsay evidence? How will you sue hearsay and the dear bua into judge no? A person to section 116 one year jumani a jumana how an adjuna maso into the judge held on point of law. That is the first ground. The second ground, judge at the time when the lawyers are mano now so no man a fundamental right, no respecting the right no man because the wheel of justice grinds what slowly what I say, but it shall surely come out with the judgment. And the judge and pray no no a hon so what catching ho now what joto now ubu so kind judgment ne ba now joto down points ne baby judge no the catching and that will be apart from the omnibus grounds, that would be the other grounds would be jinaso na nyansa for me and na court of appeal no what convince omo amoma overturn the ruling no.
All right, lawyer, many thanks for a year educational, but trendy. I'm just wondering, say be men to my was a day, but trendy, and to be the bisau as a lawyer do. To be answer, or shall yeah, move on. Beba ye na me share a can ashbe.
Okay.
Already on a but adia ba kwa trendy say or ye one advocate or no against illegal mining I did there at a point in time crop petition a year the former president on chairman wound to me. But the trends on social media say allegedly omo pulu obituary poster bia me ye the truth so say onono kra no adia all kano the yere enya penny ene Justice Kukuvi Te allegedly. Lawyer, a question say bad say conflict of interest. Is it an issue? That's a look we said. What do you want to comment?
That's so. You see, conflict of interest now so a moral issues be, but is it a law? Is a conflict of interest occur when a person's private interest, such as personal relationships or financial ties, clash with their professional duties or responsibilities. This situation creates the potential for compromised judgment, bias, or unfair personal gain, even if no unethical action has actually taken place.
Every day now, okay.
Dictionary meaning, that is
dictionary, okay.
Conflict of interest. So the point is, I don't see any conflict of interest here, because the mere fact that must say your sister be there penny ashibeno a sister penny and an idea and judge
and ashibe ayere enya penny judge and the sister-in-law.
I don't think that will have any impact.
Maybe at the comment or call here and say 20 years look is being on
personal view
with the petition as well.
I don't see any conflict of interest here because the personal interest, what is the personal interest? We are sister ayere penny na. And it doesn't mean say some personal interest tired na and let's look.
Allegedly, but group for those who defend this.
Let's call a spade and let's avoid politics and look at the whole issue holistically.
You won't give me politics.
No, I'm talking about with regards to the judgment itself. You see, looking at the judgment can the position of the law, because conflict of interest in the Kumua, so conflict of interest. No one said
lawyer. Judge can the position of the law. You are a lawyer.
Yes.
We have circumstantial evidence here. We use here. Does it tally?
You see.
No, you Chief Justice. No,
okay. You see, baby, me say who say. Judge, no, baby, I mean, say me attacking a judgment. Now, baby, I mean, say the judge was not fair to Chamawun to me. Be my say who you say. If you look at the sentencing regime of the offense now, sentencing regime no from 15 years to 25 years, or a foreigner 20 years to 25. And looking at the sentencing regime of the act, no, the new say the judge was not fair to win to me, because this is the first time win to me has had the brush of the law.
And it's a Ghanaian.
It's a Ghanaian. The first time of having brush of the law. And I feel that what me the law no one in encounter.
And I want to say direct evidence.
About what one in encounter. Direct evidence when the law says that say in judgment you can use circumstantial evidence, you can use direct evidence or circumstantial evidence, and we have authorities to that effect. As a lot of I mentioned Bia versus the Republic, I mentioned Ananifiaju versus the Republic. Okay. But the name person make can say the Ushimua a 20 years now, the Kokoto, and not just a medal. I'm not in a cocoto yet. I
can also come beyond 25 years.
No, so what was so many minimum sentence. The minimum, because this is the first time when you had the brush of the law. And he has other family. And another point I'm a Sankachi judge and say at that time, no, and yet amicus curia, and yet friend of the court, lawyer or no can be man. Wouldn't to me didn't get a lawyer as a bit my plea litigation. After judgment to be anonym, I was my convicted. We are now actually say or sentence never follow, but me per se be defer sentence no lawyer ni here. To let me defer the sentence, man ko echina na me the sentence now. And you can order for to me say emfa no police custody. Then the lawyer ne ba uncle police custody for bare 1 week and now 2 days. The lawyer ne ba a court order. The lawyer ne ba or may plea litigation plea. Now
COVID said you open
no man 20 years. So it was a friend of the court, lawyer no, and 1 year litigation plea at the man and the court did not even listen.
Yeah.
So there are several forms of punishment. Obey used as a deterrent to others. Somebody when you're the first time of the brush of the law, first time. Now judge now man severe punishment. It's another way of bit my catching. Prosecution need not be a witness. Now prosecution, you see, the wheel of justice, and I make us say it shouldn't be at the whims and the caprices of the attorney general, but you need to balance the right of the accused with that of the right of the prosecution. And yet arbitrariness of the prosecution, and now on my new or they judgment, so that after which maybe but also will take you time. But when a judge mistakes are Nkansah judge no wa from you said the judge held on point of law.
But you see what misbehavior of a judge.
Yes, I know. I don't know to be a legal professional.
Such please look on the judge. So to be on
the legal professional conflict of interest be kind. We do versus Renchua. And me say na judge there was a conflict of interest. The okan be the babe bogui. But me I issue with there and there is no conflict of interest. But the mechanic say there is still hope. As a judge no catcher, they should read the judgment very well. But no problem and me person the problem is say the lawyer okoye no and we say e kwa appear only lawyer na we wait ma for another lawyer for mesre lawyer and the appear could be enye gidigidi Mr. Nanidium, with all due respect as a senior, MPP lawyers is on Bembia, on Homeka, so that the lawyers for the New Patriotic Party, I'm not saying that these lawyers are far better than why not from the Dobia as a lawyer, but lawyer Gary Macon, lawyer Etua, lawyer Bibi say Attorney General, yes. What I say, when you have a good legal representation, Emma Ujume de Kwabina Sam Kujo. But the lawyer there by be said cross examination with her. Cross examination yeah. And then I made regulation in Bano. It is a regulation of LI 2181 ingredients now on. I saw the cross examine star witness no. So we ain't star witness now. Before say the star witness now then a circumstantial evidence. Evidence how you don't work a crabby, I will resist single doubt. Because proving beyond reasonable doubt is about 97%. We errors of more. And when there is a single doubt, I'll be with it will kneel to the benefit of the accused person. In the cross examination, the star witness and Okuno, and you can send community general that can cry one day. What I say, Nanka was almost person use legal gymnastics, want to me for witness and quite 500. It is a matter of slowing the case. When you realize that, say, it's a what you do one who's about charges or the lawyer and the appear could be no lawyer for common case. But on now other lawyers but it's a professional lawyer. But Sadia can actually alleged though, it is alleged. Ghana for before on tea. I would do the hair. Me no. It is allegedly. It is alleged. I would do the can I should better hair. Me no. And then you say, hey, 1 million. It is alleged.
Conspiracy theory. Anyway, but that's it. I think OTA submission lawyer me actually dream see ade baako so the target was Kyeremanteng. Yes, I said Kyeremanteng was the target. And I'm going to say when the nan was in Bintia I be say am for tribunal there but the next time wouldn't be because Henry now Mr. Henry no nukodin someone no abai ni mo fa Mr. Henry no so media dance here against Kyeremanteng. And the Nkansah Kyeremanteng was the targeter. When the entire he was the target. Because no man Henry no ekwa assassin so nko di juma. And Henry na kwa di juma ene Ghana mabo obira. It is a sembra no ye pese embra ni di na chese eye deterrent to others e bomb mu amanfo hu afofo mu se dabi se de ade ma wanya se wokoya ade se Ghana ye nsuo ne ensase a se Henry ne zanka etwe na so na ebi akase wo Kyeremanteng mu na asoma nte ebi a asotwe no se de kakra ma we de Henry ni momo okodi nsamone no abai no ma Henry ni mom be ya dance ebedi adanse etia Kyeremanteng ama Henry ne wafa no ho di watifie didi be Kyeremanteng de onkodam fie dio no eji aka je Kyeremanteng was the target of this government want the way ninti ne yakasa because some in Ukraine what na sia na hwemu a anu adi as en shobi an said nyinam en shobi an said nyinam na yeka o say lawyer no judge no who read judgment na obesi ni ruling no on circumstantial evidence this is where dia versus the Republican. What is circumstantial evidence? Just any direct evidence. And now, we share a 15 years to 25 years. The number person can say, one any direct to convict the person. Who here say, dear Mr. Henry Nika and also, and I do what to me attend. Now, one direct evidence, and Canadian says, and Kabako. At the lowest, 15 no, because Kyeremanteng I a first offender. First time offender means that Kyeremanteng akwaya bibi say am ya kwachina tum. But woman 20 years. sɛ wɔnkɔ. You see, Akonta mining is a legal entity. Adentina count 1, count 2, count 4, count 5 no. Edie or charge Akonta mining. Say Akonta mining eka say ni abo e be 120 times be say brane betua. By count 3 and 6 ni die or you view from Akonta mining e prosecute and I convict Chamawun to me. Why? Because in company law no me ba tell say lawyer wa ha company no e different from the ownership of the company. E jadentina count 1, count 2, count 4, count 5 there ye charge company na Akonta mining na count 3 and 6 there ye invade free or e charge a convict Chamawun to me. Na me dey make nyina ne say if you be judicial president and say na ho e say ye nuanu matwa to yi ye meet different obi a say judge ne be kan say indeed Chamawun to me akoye galamsey won the concession ne so a enka me nkasa because say ne wakoye ene mra ne wudi but judgment na say Chamawun to me koye galamsey won asase so na mom obi a wo so man say won kwadi djuma wa asase ne so no onu mom na akotu efuma gudie na say ni pan kra de onfa ne honi na Chamawun to me de yankodam 20 years de omo ye ana make o me se make o ochira bi o dama mines concession no
yo ayo
wa Ibrahim ama ana ye ne dia ni nia dia ama no se ochira bi se ye wa Ibrahim ama so mon kwafo so mon kodo asase ne so na ni baba no so no kwafo no ono mu tu galamsey a etre se yetimi jeli ye wa Ibrahim ama ne ye
ai
bomba so me de bado no
mate honorable
na minia saa ne ma we ekoso no de Ghana fo ani abere hwe ho no enya bi ne o Chamawun timi so okọ galamsey etuntwai
atwa ya fe kra do butu ne ne
eni etie enkofo koma di Ghana fo enye komketwa
mate
Ghana fo enye komketwa ena nkukwa nkitenkete yetimi do over 1 billion yase nkukwa na ya mu we yase yasawe asembe bade
NSS de na ebobo bar afede sule wo be kan ya so ba kan so be we but ya ba NSS de yo ni etiado na
what to boss me chiao
why ya ba ntini no
watku me chiao na afi so na mini engineer ko bi amo mensa birthday me man happy birthday
all right me da say
me so me de man si na me chia na na akwaboa continue so chia mo nyina
na varies ewo Italy Portnoni yeah varies a very good evening to you mate
why na ma chia me nua ma no mo nyina Emilia Ellen
mate cancel me da say
makunta wo asante guy kwa me je me chia
ya beda bujina say beda ye honorable Frank Edisi Poku beda na spada mada ye lawyer Evan so say bu sunso as baby ya do ye say brekra but who say me near DJ B na ye say the sex tape yeah Ghana for Nature Medics Consult. Yeah, Ghana for Buja Sababo Tumobo. Nature Medics Consult. Gas to make sure, prostate plugs make sure, the benzo plugs make sure.